jail, get your client brought to the jail court and appear via Zoom. So, all right, good morning. Welcome to the 294th District Court. I am Judge Chris Martin. When I call your name this morning, if you're on the docket, please say here or present. Raise your hand so that I can see and hear you, so that I don't write down, issue a warrant for you. Okay? Christopher Mata. Christopher Jean Mata. Jaime Zarate.
Your Honor, we filed a waiver. We got hired late yesterday afternoon. We filed a waiver. I talked to Ms. Barker and apparently that's an issue.
All right, I believe that pretrial was requested to be set on February 11th.
That is correct.
All right. If the waiver of arraignments in due accord, then the court will approve that and set for pretrial on February 11th.
Thank you.
Justin Devine.
Your Honor, he's in the county detention facility.
Oh, that's correct. I see. Thank you, Mr. Ashmore.
Had a bad meeting.
Tanya McBride. Tatiana McKnight. Candace Munoz. Brianna Musgrove. Brianna L. Musgrove. Mr. Ashmore, have you heard?
I'll be in contact this week, so if I can step out of it, I'll call her.
Okay. David Nichols. Vincent Oyeda. Mary Rumbo. Mary Elizabeth Rumbo. Robert Yates.
I think he's in the basic detention, so.
Okay, I don't have that indicated on my docket, so we'll double check that. Olton McCurley. Keisha Everett.
Your Honor, she's in custody, and the last I checked, the state was in the process of verifying her financial obligation.
Okay, that some of this has not gotten on my docket, so
We think she's made bail. Is that English?
I checked the website this morning.
Oh, she is in custody still. Okay.
Jerica Simpson. Chad Atkins. Is Mr. Atkins in jail? Mr. Knoll.
Good morning, Judge.
Good morning. Mr. Knoll, is your client, Mr. Chad Atkins, in jail?
He is. I actually informed Ms. Barker of that, but I sent an email with what I thought was some additional information to Mr. Woodwick. I've not heard back from him. There will be no need for any other pretrial. I guess we'll set it for trial and see what happens.
Okay, I'll recall in just a moment.
Thank you.
Dakota Pfeiffer. Dakota Pfeiffer. Is Dakota Pfeiffer in jail, Mr. Knoll?
He is. I'm sorry, Judge. I answered that, I think, before I had my mic on.
Well, that's okay. My docket isn't. My docket's not correct today. Jamil Thompson. All right, Mr. Thompson, I see your attorney is online waiting. We'll bring him in just a moment. Jason Cravey. Jerry Lunsford. Yeah, that will be possible. Right, is there anyone's name that's in the courtroom that I've not called? Your name, ma'am? Yes, Mr. Rumbo, I believe I called your name earlier. Why were you not here at 9 a.m.? All right, Mr. Ashmore is here. We'll call you in just a moment. All right, counsel, do we have anyone that's present in the courtroom with a client present in the courtroom that's ready? All right, Mr. McCurley, if you'll step to the center podium. Mr. Bingham, if you'll come to this podium. This is cause number CR 1282, State versus Bolton Dean McCurley. So that we're set for status today.
Judges, we had filed a motion for early termination in this case of his probation. It was my understanding, talked to Mrs. Tonda Curry, that there would be Stephanie Clark, whose probation officer, would be here today as well. That's probably the only witness we would have in the case. That's it. So it'd be a brief hearing, but we would have a witness.
I'll read.
Thank you.
B.
Good morning, Mr. Robertson. How are you, sir?
I'm doing fine, Judge. You doing okay?
Yes, sir. Doing well. Mr. Robertson, are you ready on your client, Mr. Thompson?
He should be present in the courtroom, Judge.
He is.
I'll talk with the district attorney's office.
Just a second. Mr. Robertson, if you'll go ahead and step up. Thompson. Jamil Thompson, CR 10176. If you'll come to the middle podium there. We'll give him a chance to get up here, Mr. Robertson. So he's
Yes, sir.
Give me just one moment, okay? That's good. All right, Mr. Thompson, can you see your attorney, Mr. Robertson?
Yes.
All right, Mr. Robertson, I'm sorry. Go ahead, sir.
Yes, Your Honor, I spoke with Mr. Cox the other day with the district attorney's office, and we were going to see if we can have an extension on this case. It's been brought to my attention that there's some more medical issues with Mr. Thompson. Also, Judge, it's my understanding he's going to have a hearing with the SSI in the near future about his back pay and his money, so we can possibly get caught up on the money allegations also, Your Honor.
So your request is for an extension, another setting on the motion to revoke?
Yes, Your Honor.
What's the state's position?
No objection, Your Honor.
Do we know about how long we would anticipate we would need, Mr. Robertson?
Judge, it's possible we can get 60 days. Everything should be taken care of in 60 days.
Any objections, state?
No, Your Honor.
All right, Mr. Thompson, we're going to reset your case until February 23rd. Do you have any conflicts on that day, Mr. Robertson?
No, Your Honor.
All right, we're going to have Mr. Thompson sign a notice of appearance with that new date of February 23rd for a hearing on the motion to adjudicate. Motion.
Yes, Your Honor.
And we're going to give him a yellow copy of that, and then he's going to be free to go.
Thank you. Is that it? That's it for me?
Unless you want to stick around and represent some other people.
That's it, Judge. I appreciate it. Thanks.
All right, thank you, Mr. Robertson. Have a good day.
You're welcome.
May I approach, Your Honor?
Yes.
These are on Mr. Ward, who is in jail. I don't think Mr. Sanders will have any objection to that.
All right, cause numbers CR 18384 and 385. State having submitted its motion to withdraw the motion to revoke and terminate community supervision. Court hereby grants the state's motion, finds that the defendant state have modified the community supervision conditions, and Mr. Jeremy Ron Ward is continued on community supervision with said modifications. So we will not need Mr. Ward at all. Mr. Jeremy Ron Ward, CR 18384 385. Mr. Ashmore, if you'll come to the podium, please. You are the lion's share of the docket today. I'd like to kind of put your clients in order so we can know what to expect and what you have a mixture, I believe, of clients in jail and out of jail. So I think once we get you in order, then
Yes,
you'll
Your
be
Honor.
able to move more efficiently on the docket. So can you give me just brief announcements of what you anticipate on each one of your clients?
Yes, Judge. We're just going to have to ask the court for a reset with Mr. Justin Devine. He's on that first page. He's got 2 charges, and
Okay, that
he's
was
in the Hunt County Jail, and we've tried to contact Hunt County, but it's Christmas time and what have you. I think we're just going to get the district attorney's office to get us some plea papers, and I'm going to try to run up there and see him after court today.
Okay.
So we'll just continue that one. Mr. Howard is in the Van Zant County Jail and has a brand new evading, failure to appeal, bail jumping and failure to appeal. So he needs to be arraigned on that. And that'll just take moments. And then now this new charge is gonna, I would presume, I'm not gonna get an apology and a dismissal. So we're gonna likely have to rethink the plea agreement we previously had talked about. So I don't think we'll have a plea agreement on him today either, sir.
Are you ready for arraignment on that one when it's?
I am ready, but I haven't had a chance to talk to him about the charge, but I'm pretty sure he knows what it is. And we'll just have to do that one on the record, Your Honor. And then Ms. McBride is here and present, and we have a plea offer, and there was some discussion about a restitution hearing. There's been an additional fact come up that the state and I are negotiating on about potential other responsible parties because of the size of the theft. So probably, I don't know if we're gonna, I haven't had a chance to talk to Mr. Cox about, are we gonna strike a deal on that, close that today or not? Yeah, Ms. McKnight has a pretrial diversion offer. I just need to go over that paperwork with her, and then we'll wrap that up. And then I need a minute to visit with Ms. Munoz. And Ms. Musgrove, I believe, is here and was downstairs. Ma'am, you're here, right? Okay, oh, sorry, I see you back there. Okay. And I need a moment to visit with her as well, Your Honor. I request that. And then I have an offer to resolve Mr. Nichols' case, but I've made a counter proposal, and I need to visit with my client briefly about that. Mr. Ojeda is here on a request to early discharge probation so he can join the armed forces. And we're waiting on his recruiter who's on his way. And Ms. Rodriguez is in the Van Zant County Detention Facility, and that's just going to be reset for trial. And Ms. Rumbo, this young lady right here, checked in downstairs thinking she had a misdemeanor setting today, but she's here. I need a minute to visit with her. I don't have an offer from the state yet. Mr. Tabby is simply going to be a reset for trial and, or excuse me, for our pretrial setting, and it's the same for Mr. Yates.
Okay.
I didn't realize all these pages.
You are all those pages.
Wow,
Okay,
okay.
good. All right, that gives me some kind of idea. Okay, so I'm going to let you go off and start speaking with your clients that are
Absolutely.
here, and then we'll wait and call your inmates probably towards the end of removing some of these people out of the courtroom.
Yes, sir. Thank you, Judge.
You're welcome.
Merry Christmas.
Mr. Gimbel, on Miss Everett, my docket says it was set for a plea today. Are we still anticipating a plea?
Your Honor, my conversation with the state, she has not fulfilled her financial obligation, which was part of the plea agreement, and she's still delinquent, I believe, $300. And after the hearing, if I could go out and visit the jail, I could get more idea of when she might fulfill that obligation.
It's a TDC offer, Your Honor, that is contingent. It's a low TDC offer contingent on her fulfilling her financial obligations. She has not yet done so. As Mr. Gimbel said, we're going to leave that 3-year offer on the table. In the meantime, she's in custody. She's gaining credit towards her TDC sentence. But she's close to having her obligations fulfilled.
And so you also have you have Miss Simpson, Jerica Simpson. Miss Simpson's not here, correct?
She is en route. She'll be here shortly.
All right, Mr. Bingham, are you ready?
I am, sir.
All right, let's go ahead and proceed on yours. And Mr. McCurley, we're gonna have a witness, is that correct?
Judge, I don't think so. I mean, we'll have a witness, my client. I talked to Mrs. Curry. I know she's very busy. It was my understanding the probation officer will be here, but I don't see him. So
Probation officer.
it is Stephanie
Clark.
Clark.
And we have the director of the probation department here. I mean, if we need to get Ms. Clark here, we can.
I'd called her and I've not got a return call. I'm sure she's very busy as well. So that's okay, Judge. We're ready to go with Mr. I can call my client to the stand and get the evidence that I need to, I think, Judge.
All right, let's do this. Mr. Gimbel, if I can have you leave council table and let's move this podium here, bailiff, if you don't mind. Let Mr. McCurley sit down with Mr. Bingle. We'll put 2 microphones down there. You can have a seat, Mr. McCurley. All right, this is cause number CR 1282, State versus Olden v. McCurley. This is the defendant's motion for early termination of deferred community supervision. Is that correct, Mr. Bingle?
Mr. McCurley, if you would.
Hang on, I'm sorry. Mr. McCurley, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Okay, put your hand down. Go ahead, Mr. Bingle.
Mr. McCurley, if you don't mind stating your name for the record, spell it for the court reporter.
My name is Olton Dean McCurley. It's OLTON DEAN MCCURLEY.
Mr. McCurley, is it true I'll show you since we're sitting here together, copy of the judgment. You went on deferred adjudication back in October 2018 for injury to a child. You say 5 years deferred from a Judge Drum, I believe. Is that correct?
Yes, sir.
Since that time, you've been supervised. You're on probation out of Van Zandt County, supervised in which county?
I'm supervised in Hopkins County.
As a condition, and I know the judge had this in his court's file, but as conditions of your probation, you've been ordered, you had a long list of terms and conditions that you had to fulfill. Did they include paying probation fees?
Yes, sir.
Did you have to attend classes?
Yes, sir.
Did you have to submit to polygraph examination?
Yes, sir.
There was a list of things you needed to do. Have you complied with every one of those conditions?
Yes, sir, I have.
Are you current on all your fees?
Yes, sir.
Going back, this was an offense. You went on probation in 2018. The date of offense was June 2011. Is that correct? How long were you on bond and fulfilling conditions of bond before you went on probation?
I was on for some time until I pleaded.
So 7 years.
Yes, sir. 7 years.
Did you, in the time you were on conditions of bond, did you have to get permission to leave the county?
Yes, sir.
Did you have conditions of where you could eat?
Yes, sir.
Could not drink alcohol? Did you comply with every condition over those 7 years that you were on bond?
Yes, sir.
If I'm the judge or someone making a decision, I guess I'd want to know, been on probation 26 months of the 60 months you were ordered. Why not just finish it out? Why do you want your probation to be terminated early?
And further my career.
You've done everything probation's asking you to do. What are your 2 kids' names?
My son is Hunter, and my daughter is Haley.
Okay. Hunter is how old now?
He's 10.
Okay. And you have not seen Hunter since 2011
Yes, sir.
because your conditions of bond and probation forbid it.
Yes, sir.
Have you seen, how old was Haley when you went on probation?
3 months.
And she's
So, I believe 9 years old.
and have you seen her over the 9 years that she's grown from being a 3-month-old baby?
No, sir.
We've talked about this case. I told you it's purely within the discretion of the judge. True? I told you that injury to a child is, and you had cases 1245, did you not?
Yes, sir.
That people get nervous when they let people off probation with offenses like injury to a child. They don't want you to get out and do something, right? You have been under the authority of the court for 9 years.
Yes, sir.
About, give or take. Have you always complied with the conditions that the court has imposed upon you?
Yes, sir.
At this point, you're asking the court to early terminate your 5 years deferred, allow you to, back up. How does getting off probation further your career?
Because I can actually be able to go out of town and actually work at the company.
And your company is the state of Texas?
Yes, it's TxDOT.
So how long have you been with TxDOT?
See, I've been there 3 or 4 months.
And do you have a CDL?
Yes, sir, I do.
Because where you work is, not everyone has a CDL, is that fair? You know. But with your CDL license and working for TxDOT, you could further your position with TxDOT, not a company, with the state of Texas, and move up because you'd have the opportunity to do additional things.
Yes, sir.
Mr. McCurley, if I ask you, do you understand the serious nature of the offense that you were charged with? What would be your answer? Do you understand the serious nature of it?
Yes, sir.
Have you done everything you could do, and have you complied with every condition?
Yes,
Because you understood the serious nature of it.
yes, sir.
Judge, we'll pass witness to state.
Mr. Cox, any questions?
Yes, Your Honor. Mr. McCurley, you were originally indicted for aggravated sexual assault of a child, correct? Yes, sir. Okay. You pled to this injury to a child. Who was the victim on this case? The victim would be Aiden. What's the relationship of the victim?
He was my girlfriend's son.
Pled to 5 years deferred, and you've been on probation a little over 2 years now. Would that be correct? Yes, sir. Okay. Now, you were also ordered to apply or to complete sex offender conditions of probation. Is that correct? Yes, sir. You completed sex offender treatment. I call Miss Park or Miss Burns, and they say you haven't completed sex offender treatment. Would they be right or wrong? If you're not sure if you completed sex offender treatment, you can't tell the court that you complied with all your conditions of probation, can you? As far as I know of, I have completed them. That's what, Your Honor.
A few questions, Judge. I imagine if you hadn't completed everything, that they'd have an application to revoke or to proceed, wouldn't they? You continue. Part of it. What that's confusing is that I'll show you. You took the classes that were ordered as part of the sex offender treatment, and you took them and completed them because you gave me the certificates, did you not? Let me show them to you. Forgive me. Show you right here, the certificate. What does that say that you completed?
Ultimate verdict.
Judge, he's going to take the class. So we'd ask him if this refreshes his memory on which classes he took.
I'm going to sustain the objection and just ask the witness not to read anything that's not been admitted into evidence.
Yes, sir. Let me show you a document to refresh your memory. If you just look at that, don't read it out loud. Does that refresh your memory on the certificate, the class you took?
Yes, sir.
And what was that class?
The sex offender class.
You also, did you take and complete the sex offender chaperone training?
Yes, sir.
Did you take and complete the certificate of completion of an anger management program?
Yes, sir.
But you understand, injury to a child, you can never be a sex offender. Why would you take those classes? You didn't have to. I mean, you had to, because the court told you had to, but I mean, you're not a sex offender. You took them, right?
Yes, sir.
The ag sexual assault of the child was 1245 by the DA's office, was it not? In other words, dismissed.
Yes, sir.
The victim, Aiden, your girlfriend, did you know, excuse me, had you seen her or that child in 10 years?
No, sir.
Now in your paperwork, there was an amendment to the conditions of probation that said that you submit to and attend counseling, correct?
Yes, sir.
There was also a case plan that said that that would go on for 12 months, right?
Yes, sir.
How long has it gone on for?
It's gone on.
This was submitted, it was ordered June of 19, right?
Yes, sir.
It's past June of 20, right? So you've actually gone further than what the case plan provided for.
Yes, sir.
Why'd you do that? You didn't have to. Ordered?
I was ordered to.
Let me show you one other thing. There was also in your paperwork, it made you aware that you were eligible to have this early terminated for I guess the court or probation. It was something you were provided, and it was signed October 29th, 2018. And it said that you were eligible when you had served 1/3 of the original probation period or 2 years. That was eligibility for early termination, correct?
Yes, sir.
And you're past that, right?
Yes, sir.
But you understand, eligibility doesn't mean the judge has to do it.
Yes, sir.
Judge, that's all we have.
Questions, Mr. Clark?
I just have one follow-up question. Mr. McCurley, your lawyer talked to you about 1245 and those cases that were dismissed. Do you recall that?
Yes, sir.
Okay. Are you aware that under section 1245 that take responsibility for those offenses and your court takes that into consideration? That's your punishment. Are you aware of that?
Yes, sir.
So you took responsibility for those offenses?
Yes, sir.
Okay. Pass a witness.
That's all we have, Judge.
Any additional witnesses?
No, sir.
If you'd ask for a quick recess, Ms. Clark's on her way to testify.
Court will stand in recess for a few minutes and some other cases.
Thank you, Judge.
I think it was
Well, how was the wedding?
Mr. Knoll? I just want to give you an update. I believe that Mr. Atkins is engaged in a parole hearing with Zoom. So as soon as that's completed, they're going to join us via Zoom while your client first.
Okay. On Pfeiffer.
Oh, on Atkins?
Okay. He said again today, because I think he's got, he's the one that has also a new drug charge.
So he's set for a docket call on evading and evidentiary hearing on the drug. Anyway, I'll let you make that announcement when we get him in, but he's going to be our first. So I just want to let you know that. But the reason they're not here now is I believe that they're doing a parole hearing with him via Zoom. Just want to give you that update.
Okay. Thank you.
testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? And can you move a microphone to her? I'm sorry. All right, ma'am. Are you Jerica Dion Simpson?
Yes.
Okay, make sure you speak up loud enough so my court reporter here can see and hear you, okay? Can you see? So, Mr. Gimble, do me a favor. If you'll slide that over, and if you'll just come over to this one, then that way you'll be on camera. All right, Miss Simpson, just make sure you speak up loud enough for my court reporter here so she can hear you, because she's got to take down what you say, what everyone says, okay? Okay, and you got to answer out loud.
Okay.
Okay. All right, Miss Simpson, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes.
What have you been diagnosed with?
Schizophrenic and spelling.
Okay.
Like
Are you currently on any types of medication for those disorders?
No, not at the moment.
Do you feel like the fact that you're not on medication is inhibiting the way that you can understand the proceedings today? Do you feel like you're confused or you don't understand?
No.
You feel like you understand everything that's going on in this case?
Yes, sir.
Do you understand what's going on here today?
Yes, sir.
In this case, you're represented by your attorney, Mr. Brent Gimble. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk to him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed that you do not understand?
No.
And you've read and signed your conditions of community supervision. Do you understand those?
Yes, sir.
Mr. Gimble, do you believe Ms. Simpson to be competent today?
I believe she is, Your Honor.
And have you seen any evidence of anything that would cause you concern with her mental disorders and the lack of medication for those at this time?
No, Your Honor.
Okay. And so throughout all times of your representation, she appears to be competent and understand the proceedings against her?
I believe she does.
All right, Ms. Simpson, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and carries a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
Now, there's an agreement in this case wherein you're going to agree to plead guilty to that offense in exchange for the state's recommendation that the court defer a finding of guilt. That means that the court review the evidence and determine whether or not there's enough evidence to convict you of this offense. And if the court does that, the recommendation is that the court then defer a finding, not convict you of this offense, but place you on community supervision for a period of 5 years. And says a $4,000 fine in addition to reimbursement fees for attorney fees and court costs. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you want to do today?
Yes, sir.
Is that your understanding, Mr. Gimble?
It is, Your Honor.
All right. So, Ms. Simpson, at this time, the court's going to ask you, how do you plead to the second-degree felony offense of aggravated assault with a deadly weapon?
I do.
No, do you plead guilty or not guilty to that offense?
I plead guilty.
Okay. And Ms. Simpson, are you pleading guilty to that offense because you are guilty of that offense?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to plead guilty to this offense?
No, sir.
You're doing this of your own free will and accord. Is that correct?
Yes, sir.
All right. The court will accept Ms. Simpson's plea of guilt at this time. Mr. Gimble, is there any objection to States 1, the stipulation of evidence?
No objection, Your Honor.
States 1 is admitted in evidence, and the court takes judicial notice of Ms. Simpson's judicial confession. Is there anything further from the state?
No, Judge, rest to close.
From the defense?
Nothing further, Your Honor.
All right, Ms. Simpson, based on the court's review of the evidence, the court finds that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement in your case. The court hereby defers a finding of guilt in your matter and places you on community supervision for 5 years. The court assesses a $4,000 fine, orders you to pay court costs of $290 and reimbursement fees of $785. Ms. Simpson, have you ever been on probation before?
No, sir.
Do you understand that by the court approving this plea agreement and placing you on probation, you're going to be supervised by a probation officer, and you're going to be required to comply with all of the conditions of probation that was in this paperwork that you read and signed? Do you understand that?
Yes, sir.
And do you understand that if you violate those, if you commit another offense, if you drink alcohol, if you test positive for drugs, if you don't do your community service, if you violate any of these conditions, you understand the state can file a motion to adjudicate your guilt, bring you back before the court, and then they could argue to the court that you violated. And if they prove it to the court that you did that, the court could revoke your probation, and the court could sentence you up to 20 years in prison. Do you understand that?
Yes, sir.
Do you understand how important it is to comply with your probation?
Yes, sir.
All right, Ms. Simpson, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward here with my bailiff to be fingerprinted. After that time, I want you to join Ms. Burns here for probation, and she'll give you further directions, okay? So go ahead and step forward here with my bailiff.
Your Honor, if I could be excused, I will go to the Van Zandt County Jail and can appear with Ms. Everett once I verify her status.
Yes, sir, please do that. I appreciate it. Just let them know when you get there to have her pulled.
Thank you.
Judge, we finished with Mr. Knoll's cases.
No, his cases haven't been called yet. We're waiting for the jail to join us. They were on a parole hearing,
Okay.
so we haven't seen them yet.
And Your Honor, it's my understanding from Ms. Burns that Ms. Clark is here and ready. Bingham's ready.
Ms. Clark here. Can we go ahead and move hers? Can you take her back? It's going to take her back there. Mr. Cox, will you do me a favor? Can you slide that podium over so that we can have Ms. Clark here so she can see? Mr. McCurley, if you'll come up and have a seat with your attorney, please. Slide right up against that box. Perfect. Thank you, sir. Ms. Clark, if you'll come around here to the front. Right, we are back on the record in CR 1282, State versus Olton Dean McCurley. If you'll raise your right hand, ma'am. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Please have a seat and good spots. If you'll adjust that microphone for yourself, pull it out, pull it out.
Good.
All right, go ahead, state.
Thank you, Judge. Ms. Clark, would you state your name for the record, please?
Stephanie Clark.
Ms. Clark, how are you employed?
I'm employed with Van Zandt County CSCD.
What are your job duties with, well, and when you say CSCD, Community Supervision and Corrections Department?
Yes, sir.
correct? Otherwise known as probation.
Yes, sir.
What are your job duties with the probation department?
Supervise offenders when they're placed on probation and report back to the court on compliance or non-compliance.
And do you also supervise offenders who are placed on sex offender conditions?
Yes.
What are some of the different conditions on sex offender probation?
They cannot have contact with minors, cannot go into child safety zones. They have to attend sex offender treatment, cannot have internet access, cannot view pornography, various other things.
Okay, they have to do polygraphs, stuff like that,
Yes.
correct? Okay. Are you familiar with Olton McCurley?
Yes.
Are you supervising him currently?
I have him on, he's a transfer out. He's actually being physically supervised out of Hopkins County.
Okay, but you're responsible for his case, correct?
Yes.
Okay. And he was placed on 5 years deferred adjudication probation for injury to a child, correct?
Yes.
And was one of the conditions, well, let me back up. His conditions were modified at one point to where he has to comply with the sex offender conditions, is that correct?
Yes.
Okay. And one of those conditions is that he be successfully discharged from sex offender therapy, correct?
Yes.
Would you tell the court a little bit about what sex offender therapy is?
They go
Well, the court already knows, but for the record, sex offender
they
therapy.
have to attend treatment with a sex offender treatment provider where they get treatment to hopefully not recidivate and commit new sexual offenses.
Okay. And so that was a condition placed on Mr. McCurley, correct?
Yes.
Has he successfully completed that condition?
No.
So he has not been discharged from sex offender treatment?
No.
Okay. I'll pass the witness, Your Honor.
Mr. Bingham, any questions?
I do. Mr. Clark, how are you?
I'm good. How are you?
I'm doing fine. I called you and left you a voice message on your phone a couple days ago. Did you get it?
I did get it.
Did you call me back?
No, sir, I did not.
Why not?
Because I've been very busy.
All right. I called you this morning at 9:13, asked you to come over, and I noticed you didn't return my call then, but you came back over, I guess, the call of the state.
I may not have been in my office. No, my director called and told me to come over.
I got you. Would you agree, Mr. McCurley, when you say he's not been successfully discharged, doesn't mean he's violated anything. It's just that treatment's ongoing until it stops.
Yes, he's ongoing until the treatment provider feels that he's successfully completed and releases him.
Right. And we don't know what her position is because she's not here, and you couldn't say because it'd be hearsay, right?
No.
Right?
I don't even know his treatment provider. I've never worked with him.
Then how in the world can you say that they're recommending he not stop? Or did you say that?
I did not say that.
Okay. You're just saying that it's ongoing until she or he or whoever the provider is says it's not.
Correct.
But
Until
he's
they
not, I'm sorry.
Until they release him.
Right. And to your knowledge, Mr. McCurley is not in violation of anything. He's done everything he's been asked to do, has he not?
That I'm aware of.
Okay. Well, if you're not aware of it, I guess you'd be the source, wouldn't you?
Or his probation officer over in Hopkins County.
Well, but he would, certainly y'all would communicate, would you not?
Yes.
Okay. Has he indicated to you that Mr. McCurley has not done something he should have done?
No.
Do you keep a record of the fact that he's up to date on all his fees?
Yes.
And he is, isn't he?
Is to my knowledge when I checked it, he was.
And do you communicate with the transfer officer to make sure Mr. McCurley's done all the classes he's supposed to do?
Yes.
And he has that.
He's been attending a sex offender treatment, yes.
Okay. But he's also completed, he's got certificates of classes he's completed, has he not?
Anger management, yes.
Uh-oh. May I approach with us? Or social distance approach? All right. I would imagine you're also familiar with, just to refresh your memory.
That's the chaperone certificates that his parents took the chaperone class so that they could supervise him if he came in contact with minors.
So the one that he completed then would be this anger management?
That's anger
Is
management.
that the only one that was required?
On his original conditions, I believe so.
How about on the, has there been any added?
His sex offender conditions were amended, yes.
And I guess so I don't keep having to ask you, I don't want to keep asking you one by one. He's done good, hasn't he?
He's complied.
Okay. Well, tell me, you said you kind of hesitated. What has he not done that's you would have liked him to have done?
He's complied with everything he's had placed on him.
Okay. Do you have any problems with him?
I have not had any problems with him.
Okay. I mean, are you aware that any transfer officers have had problems with him?
No, I'm not aware of any problems.
Did you ask him to buy a camper?
No, I did not ask him to buy a camper.
What did you say to him?
I told him that if his children,
Hang on. So your question was, what did you say to him?
I'm asking the witness in court, the declarant,
Right.
what she said to Mr. McCurley.
Which is an out of court statement.
I'll overrule the objection. Go ahead.
I told him that if minors were to come live in his home, he could not reside in the home. He would have to reside somewhere else. He asked about placing a camper on the property, but not living in the house.
I see. Do y'all do home visits?
I'm not sure what Hopkins County does. We do.
And to your knowledge, he's complied with all that. Fair?
To my knowledge.
At any point during the probation, or excuse me, after he was placed on probation, did you tell him if he did not admit something to you, he'd go to prison for 99 years?
No.
How long have you known Mr. McCurley?
I cannot remember when he was placed on pretrial, but I had him on pretrial for so many years, I think. And then he was placed on probation in 2018.
Right. So would you argue with 2011, him going on pretrial release? Does that sound?
Maybe. Possible.
While he was on pretrial release, I mean, he was actually on bond, our pretrial release, for 7 years. Does that sound right? Because he pled October 18th.
I'm not, I don't know the exact date he went on pretrial.
Would you quarrel with that? Would you say, no, wait, that doesn't sound right? Or is it possible it could have been 7 years?
I don't know.
It was a long time.
I don't know that one either.
Did you do you have a file?
I can go look it up.
Well, how long does it take you to look it up?
It won't take me long.
Is that okay with the court?
How long is not long?
I can run in there and type his name in and pull up the date he was placed on pretrial.
Is that what you want to do, Mr.
I
McCurley?
do, Judge.
All right, court will take a recess, allow the witness to look up the information.
Thank you.
All right, we are back on the record, CR 1282. Go ahead, Mr. Bingham.
Pretrial. When was he placed on pretrial release?
7/5/2011.
Okay. So what did he have to do on the conditions of pretrial release? I mean, that's 7 years.
Pretrial release, he had to report weekly or monthly. I'm not sure which one he did. He reported to me, he paid pretrial fees, and he could not have contact with minors.
Did he leave the county?
Yes.
In that 7 years, if we're looking at Mr. McCurley going, is this a guy that complies? What kind of guy is he? Did he ever violate that?
Not to my knowledge.
And so for 7 years, he reported weekly or monthly, paid fees, complied with all the conditions. He's been on probation now for 26 months, done everything he's supposed to do, has he not?
To my knowledge.
Are you familiar with the case plan from 7/8/19? It was signed by you on 7/15 of 19.
I'd have to go look at it.
In there, it said, or may I approach witness?
You may.
Social distance. I'm just going to hold it up to you. There's a highlighted.
Yeah, no, I can't see it. Sorry.
Orange, what I was asking about.
Okay.
Does that refresh your memory?
Yes.
Okay. Got to get it back. You need it?
No.
Okay.
I've got a copy, but.
Okay, I didn't know. I was just asking a question. Ms. Clark, what is the case plan?
A case plan is a plan that we put in the file so the offenders and next officers after us or the state can verify that we are working on a specific goal towards completing their probation.
This case plan, it said at the top, the following are for the next 12 months unless otherwise stated. And it says, I will attend and complete as assigned my condition of supervision or recommendation by assessment. What does that mean?
You'll have to repeat it again. I'm sorry.
It says, I will attend and complete treatment as assigned by my condition of supervision or recommendation by assessment.
It just means that he's agreeing to attend his treatment until he completes it.
For the next 12 months.
And then at the end of that 12 months, we do a reassessment and do a new case plan.
Okay. And it says that counseling can be discharged by who?
It can be discharged by the provider or the court.
And at this point, you don't know who that provider is, only that there's nothing to indicate that he's not complied with that.
No, I don't know who his provider is in Hopkins County. Okay. And to my knowledge, he's complying with it.
Would you agree that he's eligible for early termination?
No.
You don't agree with it?
No.
Okay. So the law says that he has to serve, or the paperwork here says he has to serve at least 1/3 of his sentence or 2 years before he's eligible. Is this Mefrich? You mean? Is this a document here that you generate, or
our office does this?
Your office does this?
Uh-huh.
Okay. And he gave that to this case, right?
It's his conditions of probation, yes.
Okay, and what's the highlight say?
It says pursuant to Article 4212, Section 20 of the Code of Criminal Procedure, the defendant successfully completes all terms of probation and serves at least 1/3 of the original probation period, or 2 years, whichever is less. The defendant may petition the court to request an early discharge from probation.
Let me ask you something. How do you know that he's not been discharged, or the counselor doesn't want him to? Hasn't satisfactorily said he's done? You don't do.
Hopkins County would send me the discharge once he finishes.
So you can testify under oath that the counselor's position is that he is not to be discharged.
No, I won't.
Because you don't know, do you?
I don't know.
Thank you, Mrs. Clark. I appreciate it. We'll pass witnesses.
Mr. Cox, any questions, Ms. Clark?
Ms. Clark, just one thing. Mr. Bingham asked you if his client has done everything he's supposed to do. That's not true, though, is it? Because he has not yet successfully completed sex offender treatment, correct?
Correct.
That's a witness.
Okay, so you know that now. I asked you that just a second ago, and you said you couldn't testify. You testified inconsistently under oath. Which one is it?
I cannot say that he has successfully completed because I have not gotten a discharge
You can't
from the
say
counselor.
he hasn't, can you?
I would have to talk to the counselor.
You can't say he hasn't, can you?
No.
Thank you. Pass the witnesses.
Anything further, Mr. Cox?
No, Judge.
This witness free to go?
Yes, thank you, Ms. Clark.
You may step down. Thank you, Ms. Clark. Anything further, Mr. Cox?
No, Judge.
We ready for argument?
We are, Judge.
Go ahead, Mr. Bingham, your motion.
First of all, we appreciate the court getting sitting here. I know the court's busy and it's that time of year. Judge, Mr. McCurley, I know the state has brought up the 1245s. I assume there's a reason for it. The court, I don't know Judge Strong, but she took that into consideration when she assessed the 5-year deferred in this case. Now, I assume there had to be a reason that they agreed to 1245 those cases. That said, he's been on 5 years deferred adjudication probation in this court for 26 months, and he has done everything this court or the probation department has asked him to do. Mr. McCurley has not seen Haley or Hunter, his children, in 10 years. 10 years. He was on bond for 7 years, and he complied with every condition they asked him to comply with. He reported weekly or monthly. He paid fees. He stayed away from his children. His 3-month-old daughter is 10 now. I've never seen her. He has complied with every condition that probation has asked him to do in this case, the court has asked him to do. He is eligible for it, and Judge, he deserves it. It takes an effort to do what Mr. McCurley has done. He has complied with every condition. He's passed the polygraphs they've asked him to take. He's reported. He's paid fees. He's lived in a camper. He's bought a flip phone. He's done the 2 pages of conditions that this court and probation has asked him to do. We ask, and the court asks, and the community hopes that people who go on probation will do what Mr. McCurley's done. He has shown the court through his actions that he understands the serious nature of the injury to a child. He understands and respects the court's order, and he's complied with it. But I think it is very relevant that he did so for 7 years prior to that. Because we're asking that the court early terminate the probation, allow Mr. McCurley to meet his children, one that was in diapers the last time he saw him, who's now going into 5th grade, 6th grade, whatever that 10-year-old's going to. I believe any question from a DA or a judge about a case like this is, well, what down the road? I've always believed the best predictor of future is he's shown me what he can do and what he's willing to do and the serious nature. He has a family here that supports him. Mr. McCurley's earned. He has earned an early termination probation in this case. We certainly understand the state's position in this case, but we also believe that his actions have shown the court that he can move forward in his job, see his kids, and live a law-abiding, productive life, which is what we hope for everybody that goes on deferred probation. We always talk about the double-edged sword. I know I always did when I was DA for years. It's the double-edged sword. You can go for the maximum sentence if you violated it, but if you do well, you have the opportunity to have an early termination and not have a conviction. And Mr. McCurley heard that, and he did it. And we'd ask the court to early terminate his probation. He's been effectively on it now for since 2011, in a sense. Thank you, Judge.
Thank you, sir. Mr. Cox.
Judge, Mr. McCurley does not deserve to be discharged early because he has not completed everything he's supposed to do. When I asked Mr. McCurley if he'd successfully been discharged from sex offender therapy, he couldn't tell me yes or no. Furthermore, Ms. Clark testified that to her knowledge, she has not received any notification from Hopkins County that he has been successfully discharged from sex offender treatment. So I don't know how Mr. Bingham and his client can tell this court that he's in compliance and he's done everything he's supposed to because there's no evidence that he has. Finally, Judge, and perhaps most importantly, and I feel bad, I should have brought this to the court and Mr. Bingham's attention earlier. It saved us all the time and the hassle of having this hearing. But legally, under the Code of Criminal Procedure, he's not entitled to early discharge. I would draw the court's attention to 42A 701 of the Code of Criminal Procedure. It states that early termination does not apply to a defendant convicted of an offense under 42A 054. If you then look at 42A 054, that does not apply to a defendant who has been placed on probation for injury to a child, elderly, or disabled person when that offense is a first-degree felony, which admittedly this one is not, it's a third, or the victim is a child, which it is in this case. So therefore, Judge, under the Code of Criminal Procedure, Mr. McCurley is not entitled to the relief he seeks this morning.
I believe the key word there was convicted. Not being,
Based on probation.
he's not being convicted of anything.
Any further discussion? All right, court will, as in this case, go take us another matter, opportunity to evidence and use arguments. They're only going to review the law. Yeah, we'll be right back. You're free to in and out of the courtroom until we call your case, okay?
You hear us, Your Honor?
I'm sorry, say that again?
Can you hear us?
Yes, I can hear you. Thank you.
Yes, sir.
All right, Mr. Knoll, is this your client?
I think that's Mr. Adkins. It's kind of hard to see, but I think it is.
Atkins, is that you?
Yes, that's my
All
word.
right, thank you, Mr. Atkins. This is cause number CR 2237, State versus Chad Edward Atkins. And I show that we were set for evidentiary hearing today. Mr. Knoll, go ahead.
Judge, the last time this case was called, I found out a few days before that Mr. Adkins had been arrested. And I think Ms. Heisel and I have determined that the actual only new arrest is yet another new drug charge. Obviously, that case is not indicted yet. I did receive from Ms. Heisel, although I have no discovery on the new case, obviously, an offer on, I guess, to dispose of all cases. I don't think that's going to be accepted. The other problem that I've had is Mr. Adkins, for a brief period of time, was out of jail. There was an appointment made, I think it may have even been on a Saturday, for him to come to my office to review a particular video involved in the case that is presently before the court. I don't remember if I got a phone call or a text message, but he has not seen that video. I received either a phone call or a text message from his mother indicating, I guess shorthand version, he was having a bad day that day and they would not be bringing him to review that. I don't have, well, actually I do have the probable cause affidavit on the new offense. Have not really had a chance to talk in depth with him about the new offense, although we did visit briefly last time I was physically there. I'd like to have one more reset to determine if we're trying two cases when the next one comes up, or we're going to dispose of two cases with some sort of plea agreement.
State, do you have any position on Mr. Knoll's request?
Your Honor, we have no objection to a reset to try to work this out just for the court's information and Mr. Knoll's information. I don't know if he knows this or not, but there is also an assault family violence charge pending against Mr. Adkins downstairs in the county court at law. So we we embrace the opportunity to get rid of all of these cases. However, that's really up to Mr. Adkins. So we don't object to reset to try to work that out.
Judge, I knew that that was part of the arrest. I actually thought that was a prior offense, but apparently not. And I have no information on that one. I don't believe, but not particularly concerned about the misdemeanor when we've got multiple felonies.
All right, Mr. Knoll, what I'm going to do then is I'm going to reset this for an evidentiary hearing on your motion. You have a motion to suppress file, correct? Is that correct?
Judge, I don't remember if there is or isn't one. What I need is to have a client. Now I've got him someplace where I know he's going to be, I believe, so he can see the video that I think he needs to see so that we can move forward. I've relayed the contents of that video, but he's never actually seen it because the day he was supposed to come to my office, the phrase used by his mother was that he was having a bad day that day. So he's never seen it.
Well, I'm assuming since we're set for evidentiary today, the only way we get to an evidentiary docket is either by way of a court having to reset or there's a motion to suppress file.
That's why I need to have him look at the video. I have looked at it. He hasn't looked at it so that he can tell me, well, exactly. It's a body cam video. There's only one body cam video. Some of it you can hear what is being said. Some of it you can't because of a very brief struggle that occurred as Mr. Adkins was coming off of a couch, I think as I recall, where he was sleeping.
Yes, I do. I see here in the court's pleadings or the court's file, your pleadings of a motion to suppress. So what I'm going to do, Mr. Knoll, is I'm going to set this on January 28th for a hearing on that evidentiary motion. So we'll either go forward that day on that hearing or the court's going to deny the motion to suppress.
I understand, Judge. Thank you.
Okay,
And
so
I'll make sure I get there. I'm sorry, Judge. I'll make sure I get there so that he can see the video that he has yet to see.
okay. All right, Mr. Atkins, we will see you on January 28th. If you make bail in this case, it will be at 9 a.m. in this courtroom. If you are in jail, it will be at 1:30 that afternoon, and the court will have you brought before it. Okay.
Thank you.
Do you have any questions? Do you understand everything?
Yes, sir. I understand.
All right. Thank you, Mr. Atkins. Mr. Knoll, I believe that jail staff is attempting to bring up Dakota Pfeiffer next.
Thank you, Judge.
You're welcome. Court call CR 20-110, State versus Jason Aaron Cravey. Mr. Cravey, if you'll make your way to the center podium, please. Mr. Sanders, is this is on a Carol Ann Edwina Lake?
That was part of it. In case he gets hurt, that's his wife.
Okay, not on the docket today, though, right? Okay. All right, Mr. Cravey, if you will, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, you may put your hand down. Are you Jason Aaron Cravey?
Yes, sir.
Mr. Cravey, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Yes.
Okay. Are you on any kind of medication at this time? Zoloft. Do you feel like that medication is assisting you today and giving you rational thought and understanding? Okay. All right. And Mr. Cravey, in this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to talk with Mr. Sanders about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork or today's proceeding that you do not understand?
No, sir.
Mr. Sanders, do you believe Mr. Cravey to be competent today?
Yes, Your Honor, I believe he is.
You explained to him his legal and constitutional rights?
Yes, Your Honor.
And you've explained to him both the advantages and disadvantages of a deferred adjudication plea?
Yes, Your Honor.
Mr. Cravey, you are charged by indictment with the third-degree felony offense of tampering or fabricating physical evidence. Third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that full range of punishment, sir?
Yes, sir.
You understand if the court goes along with this plea agreement and the court later finds that you violated your terms and conditions of your community supervision, the court could revoke your probation and sentence you in prison up to a maximum 10 years?
Yes, sir.
Mr. Cravey, how do you plead to that offense?
Guilty.
Mr. Cravey, are you pleading guilty because, in fact, you are guilty of committing that offense?
No, Your Honor. Yes, Your Honor. Sorry.
Okay. So I think you understood, but I'm going to ask you again. So I'm asking you at this time, are you pleading guilty to this because you are guilty of committing this offense and you're not pleading guilty because someone's threatened you, forced you, or made you want to catch you?
Yes, Your Honor.
All right. The court will accept Mr. Cravey's plea of guilt. Mr. Sanders, any objection to State's 1?
No objection.
State's 1, stipulation of evidence is admitted. The court takes judicial notice of Mr. Cravey's judicial confession. Is there anything further from the state?
No, Your Honor, we'd rest and close.
From the defense?
No, Your Honor, rest and close as well.
All right, Mr. Cravey, based upon the court's review of the evidence, the court finds that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement that you've reached with the state and follow their recommendation. The court hereby defers a finding of guilt in your matter, places you on community supervision for a period of 4 years, orders you to pay a fine of $3,500, court costs of $290, and orders you to reimburse Van Zandt County $785. Mr. Cravey, I trust that you understand the significance of your conditions of community supervision and how the court views them.
Yes, sir.
All right, Mr. Cravey, you're hereby remanded to the custody of the Van Zandt County Sheriff. To the Van Zandt County Community Supervision and Corrections Department, so that they can carry out the terms and conditions of your community supervision. I'm going to have you step forward here with Ms. Burns. After that time, I want you to report to her with further instructions. The court this day is also signing R 2131, state's motion to dismiss in the state of Texas versus Carol Ann Lee. And Mr. Sanders, you said that that was part of this agreement?
Yeah. That was our understanding that would charge to be dismissed.
All right, Mr. Craig, if you'll step forward with Ms. Burns. Thank you. Ms. Heisel, are you there? Mr.
Yes, Your
Cox,
Honor.
Ms. Heisel, do you know if on Mr. Ward's case, the modification on Jeremy Ward, if the attorney fees were taken into consideration and modified to include?
Judge, I'm not sure. I emailed Miss Burns, but I did not address that with her. I'm not sure if that's something that she handled independently. She usually asks, but I'm unaware.
Okay, I'll ask her if you'll stay for just a second, or go ahead, Mr. Sanders. You can go ahead and go, and I'll ask.
And Judge, on those conditions, there was also, as a term of the agreement, that Mr. Ward was to enroll in BIP within 60 days. That was also an added term. But obviously I'm not there, so I haven't seen the amended conditions of probation.
I haven't seen it. I've just seen the motion to withdraw. So I'll inquire with this.
Thank you, Judge.
If I need to get the conditions for him to sign, I'll take that over there as well.
Yeah, I'd like to see him before you go. Do we have anyone available in the jail court? Oh, there you are.
Yes, Your Honor.
And who do we have here?
This is Mr. Piper.
All right, Mr. Knoll, are you ready?
I am, Judge.
All right, this is CR 2266, State versus Dakota Piper. Go ahead, Mr. Knoll.
Judge, I had sent some additional information to Mr. Woodwick. I assume he received it. I didn't get a response. I think at this point, we did have a combination plea offer, for lack of a better way of putting it. There's a pending deferred probation revocation in another county. There was an offer made actually from both counties for the same way to resolve those. Mr. Pfeiffer has indicated that in the case pending here in Van Zant County, that at this point we would be requesting that we be placed on a jury docket.
So Mr. Piper has rejected the offers made by the state?
That's my understanding, Judge.
Okay. And Mr. Piper understands that if he later wishes to accept that offer, the court may not be inclined to accept it?
I believe so, Judge.
All right, then the court will set Mr. Piper on the jury trial docket for jury selection beginning February 1st. And Mr. Piper will remain on that docket until his case is reached for trial. Mr. Knoll, you understand that you're not going to be required to appear at jury selection for Mr. Piper until you're noticed by the court that the case is liable for trial.
I understand, Judge.
So that Mr. Piper, if you make bail in this case, then the only notice you're going to get from the court is that you're ordered to be here on December 1st for jury selection. You will report to the basement of the courthouse.
I'm sorry, Judge. I think the court said December 1st. Did you mean February
1st? I'm sorry. Yes, thank you, Mr. Knoll. February 1st of 2021. And when you appear at the courthouse, if you're on bail, you'll report to the basement, and court staff will be there with more information. Do you understand?
I do, Your Honor.
All right, so February 1st at 8:30 a.m. if you are on bail. If you're in jail, you don't have anything to worry about. We'll bring the paperwork to you.
Yes, Your Honor. Thank you.
All right, thank you, Ms. Piper.
Yes, sir.
Judge, I believe that's all.
Thank you, Mr. Knoll. Appreciate it this morning.
All right. Yes, sir.
Bailiff, I'm sorry, I accidentally muted the jail court. Who do we have here?
This is Mr. Howard, Your Honor. I understand he's one of Mr. Ashmore's clients.
Mr. Ashmore, you ready? This is CR 2215, 252, 253, 254, 343, State versus Raymond Bernard Howard.
Morning, Your Honor.
Go ahead.
Mr. Howard has recently been indicted on a new charge for third-degree felony, bail jumping, failure to appear, and that was recently uploaded by the state in the share portal. I have not had a chance to visit with Mr. Howard about it, and I'm trying to pull it up on my phone, Your Honor, because we need to read it to him. I've memorized it. So Mr. Howard, can you hear me?
Yes, sir.
Okay. The state has charged you with the third-degree felony of failure to appear bail jumping. You understand the allegations against you?
Yes, sir.
And you understand that the allegation in the indictment specifically says that on October 20th, you failed to appear to court at a court date.
Yes, sir.
Okay. I don't know if Your Honor can share screen and show him that indictment so he can confirm that his name is spelled correctly on there. Mr. Howard, can you see that, sir?
Yes.
Is your name spelled correctly on that charge?
Yes, sir.
Okay. And today you're going to enter a plea of not guilty and allow me to work with the state of Texas to see if we can resolve this matter short of trial, correct?
Yes, sir.
Okay. You also understand that this indictment has 2 enhancement paragraphs in it. You see those there?
No, sir. Where?
There's a second paragraph and a third paragraph that on May 31, 2005, you were finally convicted of burglary of a habitation. And that again in 2017, you were convicted of burglary of a habitation. You see those paragraphs?
Yes, sir.
And you understand that those paragraphs mean that the state can seek to enhance your punishment range to the habitual offender 25 to 99 punishment range.
Yes, sir.
Okay. And again, you still want to enter a plea of not guilty today and allow me to work with the state of Texas?
Yes, sir.
Okay. Your Honor, we have, I have a reset form, which I'll get to my client. The prior offer was 15 concurrent on the other charges. I think I've reported that on the record previously, and I'm going to work with the state and see if we can keep that offer in place in light of these new offenses. Just haven't had a chance to do it because of this. This indictment was, I believe I know it was put in the portal on the 11th of December, so we just don't have that squared away just yet, Your Honor.
All right, the court's going to enter Mr. Howard's plea of not guilty into the record in CR 2343. The court will set this matter for pretrial. In addition to Mr. Howard's charge in CR 2254, burglary of a vehicle, CR 2253, burglary of a vehicle, CR 2252, robbery. We'll set docket call and CR 2215 all on the same day of February 9th.
I'm scrolling to it right now, Your Honor. Just 1 second, please. That's perfect.
So, Mr. Howard, your cases will be called again on February 9th.
Yes, sir.
All right, thank you, Mr. Howard. Mr. Ashmore.
On the
Who do we have, bailiff?
This is Frankie Rodriguez.
Sorry, I'll just say that. Sorry.
All right, this is CR 14419, State versus Frankie Francine Rodriguez. Set for today for hearing on the motion to adjudicate. Mr. Ashmore.
and we have a third degree felony impeding breath as well, which is, I think all these cases were consolidated. I do believe the court signed that order, and we're just going to ask the court to reset these for a jury trial setting.
Can you give me the cause number on the other?
Yes, Your Honor. No, I'm only showing the CR 14-00419. Let me dig into my.
Judge, it appears that the assault family violence impeding cause number is FC 20-00055.
I'm sorry, Ms. Hazen, say that again.
That's okay. It's FC 20-00055.
And Mr. Ashmore, did you ever get past arraignment? I'm looking at the county court of law's docket. It said it was set for arraignment on October 2nd. Were there any subsequent pretrial hearings in that court?
No, I don't believe there were, Your Honor. I think the only other matter that's been is to consolidate these cases before this court. And
all right,
that's
fine. That's fine. So the court's going to set Ms. Rodriguez for a hearing on her motion to adjudicate and the impeding on February 9th at 1:30 if she's in jail, 9 a.m. if she's on bail. We'll set pretrial on the impeding case, same date.
Thank you, Judge.
Your Honor,
Yes, ma'am.
may she be excused?
Do you need Ms. Rodriguez?
No, I do not. Thank you.
All right, Ms. Rodriguez, we'll see you back on February 9th. If you make bail on these cases, then you need to report to the court in person at 9 a.m.
Yes, sir. Thank you.
You're welcome. All right, I just want to make a brief announcement that the court's going to recess for lunch at 12, and I have a full afternoon docket beginning at 1, so any criminal cases that aren't resolved by the next hour and 5 minutes are going to be called again about 4 p.m. So that you're aware.
Just for a moment, Your Honor.
Yes.
Thank you.
All right, bailiff, who do we have in the jail court?
I'm sorry, Your Honor, this is Corey Tabby.
Mr. Ashmore, are you ready on Corey Tabby, CR 20-228-229, set for pretrial on each?
We just need a trial setting, Your Honor. Jury trial setting, please.
Okay, so there's no contested pretrial motions? You're wanting to pass docket call? So you've received an offer, you've received discovery, no pretrial motions, and there's all the negotiations have ceased.
We have received an offer. We understand where the pieces are on the board. I don't know if negotiations further. I would be recalcitrant to waive any right to file if I see something else that I might need to. So I'd make an oral motion. I can back that up with a written motion for leave to file an additional pretrial motion in case I hit a tripwire. I didn't see something to protect his constitutional rights. But short of that, we've got a defense. They have a complaining witness, and I don't know if there's going to be a resolution of that short of a jury trial.
Okay. All right, then the court's going to find there are no contested pretrial motions. Court will allow the defendant to pass docket call. Court's informing the defendant that no plea bargains will be accepted in this case after today. Court hereby sets this for jury selection on February 1st, and Mr. Tabby will be placed on the court's jury trial list. until his case is notified to be in the top 10, then Mr. Ashmore, you're not required to appear again on this case until we reach that time.
Yes, Judge.
So February 1st on jury selection bailiff. Thank you, Mr. Tabby. Bailiff, do we know who's coming up next?
I do. Give me one moment, Your Honor.
Yes, ma'am.
And Judge, while we're waiting on that, if we could go back on the record on Justin Devine's case. I believe that Mr. Ashmore and I have reached an agreement and we are preparing plea paperwork, but we need the court to let us know when it would be available to hear that plea so that Ms. Abney can put that date on the plea paperwork.
He is verified in custody in Hunt County. Let's set on February 9th. Do you anticipate pleading Mr. Devine in Hunt County's custody, or do we need to do a bench warrant to get him here?
No, the plan, we've had a hard time getting a hold of, the goal was to make that happen before today. Hunt County's short because of the Christmas holiday, the detention facility. So we're just going to either get over there or Zoom it out. But that's one way or the other. We plan to have all that stuff executed and then do a Zoom share. I think that Austin and Patty, Austin from my office, have been working with Patty to run all those traps. So that way he can do his plea by Zoom from Hunt County.
Okay.
And that actually, it kind of may work out better because Ms. Heisel informed me today that the Hunt County's turned what we thought were just misdemeanor charges. Now there's some felony allegations. So between now and February, that'll give him a chance to get a court-appointed lawyer there, and he'll have a higher comfort level instead of just being rushed into a plea that could have some negative impact on him over there.
Okay.
So I appreciate that, Your Honor.
All right, so we've set that February 9th, Ms. Heisel.
Thank you, Judge. And the state also filed a motion to hold bond insufficient on each one of these causes, and e-filed that on Friday. I believe Mr. Ashmore confirmed that he did get service on that. So would we also take that issue up on February the 9th if it doesn't resolve in a plea?
Yes, ma'am. We'll do that.
Okay. Thank you, Judge.
Bailiff, who do we have in the jail court?
Your Honor, this is Joshua Key.
Yes. Mr. Sanders in the hallway. You check for Mr. Sanders. Tell him we have his client, Mr. Key. Mr. Sanders is not there with you, bailiff, is that correct?
Correct.
It's my understanding, though, that he was going to come out there. Ma'am, are you here on Mr. Key's case? All right, just go ahead and stay where you're at. Go ahead and stay where you're at. Bailiff, it's my understanding that Mr. Sanders was going to come out and conduct the hearing from the jail.
Okay.
So if we can just keep Mr. Key there.
Here in the courtroom?
Yes, I'm not sure where Mr. Sanders is. I believe he was going out to the jail to speak with Mr. Key about it, and then was going to conduct the hearing. So the witness is here.
Okay, and Deputy Caspers just said that Mr. Sanders has just pulled up in the parking lot. So.
Okay, good. So if we can just have him have a seat, if that's fine, we'll recall him up in a moment.
Yes, sir. Thank you. That seat right there, sir.
Yes. Is it on a jail client or a non-jail client? Well, we don't have your jail client pulled yet.
I was able to verify her status when she gave her financial
You want that on the record so that she's part of it here? Okay, then we'll have to wait until we pull her up. So as soon as she's in front of me, I'll let you know. You didn't tell her, Mr. Gimble, that she wasn't going to be appearing in court today, did you?
The jail staff indicated that to avoid them the trouble and told her and her Zoom if I could come back and make back and forth. She's already signed her.
Okay. Does she want to make an appearance?
No.
Okay, that's fine. Go ahead and step up. All right, this is CR 1889 State versus Keisha Marie Everett. Go ahead, Mr. Gimble.
Yes, Your Honor. She is $390 delinquent, and she indicated that she would be able to fulfill her obligation as of January 1st. And I told her that as soon as she could fulfill her financial obligation, then we would be ready to have her motion to revoke hearing. And I would ask for the court for the first available setting of the new year.
All right, that's the state's request, is to pass the motion to adjudicate hearing in order for Ms. Everett to pay the $390 that she's delinquent to accept. And what's the offer that she'd be accepting?
She agreed to, well, once the financial obligation is fulfilled, the offer was for 3 years TDC.
Fine, Cindy. All right, the court will set Ms. Everett then on January 5th at 1:30 for plea. You guys have any issues that day, Mr. Gimble?
No, Your Honor, I have 2 other clients appearing that day as well.
Okay, good. All right, Mr. Sanders, are you ready, or do you need more time with Mr. Key?
No, Your Honor, I'm ready. I believe Charlene Key should be in the courtroom. I was going to call her as a witness.
Yes, she is. All right. Mr. White, would you do me a favor? Would you, Ms. Key, is it Ms. Key? If you'll come up to the council table here, Mr. White, would you do me a favor? Yes. Yes. Pull that podium out of the way. Not this way. Ms. Key, I'm gonna have you have a seat right here at that table. Yes, ma'am. Mr. White, let me put you on payroll. Will you grab that microphone? Just lay it there in front of the witness. All right, this is cause number CR 2053, State versus Joshua Daniel Key. And I believe that we're set here today on the motion to reduce bail filed by the defendant. Mr. Sanders, are you ready?
Yes, Your Honor, we're ready.
Are you going to call your client in addition to the witness?
No, Your Honor, just Miss Key.
All right. Ms. Key, if you will, raise your right hand. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right. And at all times, I'm going to need you to speak up as loud as you can, so that my court reporter can take down what you're saying, that Mr. Sanders can hear what you're saying. And that device in front of you is a microphone. So if you just kind of turn it kind of right there in front of you.
Okay.
All right. Will you go ahead and state your name for the record?
Charlene Key,
Can you spell your first name?
CHARLENE,
And your last name? K-E-Y?
KEY.
Thank you. Go ahead, Mr. Sanders.
Thank you, Judge. And Judge, I would ask that the court take judicial notice of the contents of the court's file, including the indictment and the date, the file mark date on the indictment indicating that the case was indicted April 24th, 2020.
Court will take judicial notice of the clerk's file in CR 2053.
Thank you, Judge. Ms. Key, if you would, again, just state your name for the record.
Charlene Marie Key.
And Mrs. Key, you're Joshua Key's mom, is that correct?
Yes, that's correct.
Okay. And you're also the alleged victim in this charge of arson against Josh, correct?
Yes, I'm the victim.
And you understand we're not really dealing with the facts and circumstances of the charge itself today. This is just a hearing concerning Josh's bond amount.
Okay.
And you understand his bond amount is set at $200,000. You understand that, correct?
Yes, sir.
Okay. And the fire that burned your property, it was from back in November 2019. Is that right?
November 3rd, 2019.
Okay. And soon or right after that, Josh went to Terrell State Hospital, correct?
He was taken from the day of the fire to Terrell State, yes.
Yes, okay. And then eventually he was released. I believe around December 3rd, he was taken to the Van Zandt County Jail. Does that sound about right?
That's probably right.
Okay, all right.
It wasn't long after.
Okay, all right. Concerning Josh's bond amount, which is set at $200,000, does he have the funds to bond out at that amount of money?
No, sir.
Right now, because he is in jail, well, let me ask you this first of all. He gets some sort of disability payment, is that correct?
Yes, he's been on disability for mental illness for many years. 800 a month.
Okay. As far as any of that money goes, is that something where, based on how things are set up, you or another family member would even have access to that to use to bond him out of jail?
I have no access to his account. It has built up since he's been in jail over a year. Okay. It's built, the money is built up in there, but I have no access to it.
From what we talked about, and what you explained to me, basically he would have to be released to be able to go to his bank to be able to even access any of that money. Is that fair to say?
Yes, sir, that's correct.
Okay. And otherwise, basically, he doesn't have any money that he can, or that you or anybody else could access in order to bond him out of jail at this point. Is that fair to say?
Yes, sir, that's correct.
Now, he went again to Terrell State Hospital. I guess it's been a few months ago, and been recently brought back to the Van Zandt County Jail. While he was there, were there some health issues that he was diagnosed with?
I was informed that Josh had blackouts. He was diagnosed with aortic stenosis, I believe is the term they use, which requires about a 4-hour operation to correct.
And is it your understanding and belief that having a surgery to deal with that is something that is medically necessary for him?
I would encourage him, of course, to seek a second opinion with a heart specialist in Tyler. But if that's what their specialist is saying, I believe it's most likely correct. He was born with a heart murmur, pretty significant heart murmur, and he's smoked all his life, so I'm sure it's done some damage.
At least to your knowledge and your understanding, are there concerns that you have regarding whether he is getting all the treatment he might need for that heart condition while he's in jail here?
There is a great concern on my part, as to whether he might receive proper treatment. Pray that he will.
And that's not necessarily that the jail would be intentionally not doing a good job, but just that there are certain limitations that even the jail would have. Is that fair to say?
Yes, per the nurse at the jail, she told me that they could not afford to give Josh the things that Terrell prescribed for him, and I really don't know what he's getting now.
Does that also include the prescriptions for mental health medication as well?
Yes, that was specifically the ones that were very expensive that he gets now because he's on Medicaid, but the jail could not provide those things for him. Okay. Per the nurse up there. She said, we just can't afford it. And I said, okay, well. And then he was sent back to Terrell, and Terrell put him on those medications. So I really don't know if they've kept up with what Terrell placed him on or not. I have no access to that knowledge. Josh informed me that he didn't think that what they were giving him was the same thing that Terrell gave him, but there again, I don't know.
Okay, okay. And you understand we're asking today for the judge to grant a PR bond, a personal recognizance bond for, basically for Josh to be released today. We've talked about as far as where he potentially could live if he is able to bond out or get a PR bond today. Have you been able to look into and set up some sort of place for him to live if he's able to bond out of jail?
Yes, sir. Yes, sir. I have checked into some places for housing for Josh.
And basically, if the judge were to let him out of jail today, what would be the plan? What's your plan?
Immediate plan would be to go and rent one of these. There's an RV park down the road from our old home, and it's in Van Zandt County, that we could do a month-to-month for him there, where he would have his own little RV spot. Long term, I've looked into purchasing a trailer or a spot of land somewhere for Josh to live on. But that was in Henderson County, where we live now, that, I found those places. And I didn't know if court would, look favorably on him moving. So I haven't purchased anything as yet.
Okay. But you at least have a temporary plan in place if he's able to bond out.
Temporary, yes, sir. Temporary with the RV park, and that's within the realm of what he gets on disability and what I can help him with financially. Yes, sir.
Okay. And I know we talked about various mental health issues that he has been dealing with for a number of years in different facilities he's been placed at in the past. But you understand that's not necessarily the issue we're dealing with today, as far as
yes, I understand that. He's had a long-term, ongoing history of mental illness. But he's never had any long-term treatment in a facility, very short periods of time, but in and out of probably 12 different behavioral health or mental facilities over the years, many more than one. One time, Glen Oaks probably 4 times, Terrell 3 or 4 times. So they just don't keep Josh long enough. And a little over 2 years ago, Judge Kirkpatrick had stated to me that he would see about getting Josh long-term commitment in Terrell, but that never happened. And so,
and you understand too, like I said, we're not dealing with, long-term, anything today. This is just basically an issue about what the bond should be set at, that sort of thing.
I understand.
Okay. Your Honor, I've passed the witness.
Any questions, Mr. Cox?
Very briefly, Your Honor. Ms. Key, when your son is not incarcerated, is he good about taking his medication?
He's usually pretty good, but I don't think that someone who's mentally ill often gets the signs, oh, something's not right, I'm off kilter, like you or I would, and we'll take our medication. Sometimes he maybe doesn't get that cue to take it in time.
Well, what happens when he doesn't get that cue to take his medication?
He can have a psychotic break with reality.
So if he is released from confinement, what are you going to do to make sure he takes his medication?
Yes, absolutely. Yes.
What are you going to do?
What am I going to do if he's out? Yes, sir. Very difficult on my part because he is an adult. All I can do is just make sure he has the medication available and prompt him, or ask him, hey, did you take your meds today? What's going on? And right before the incident happened, I was getting ready to call again and come up to Judge Kirkpatrick's court to get another order of medical protection signed, because I could see the signs that Josh was kind of going off track. So I was making plans to do that right before the incident happened. Unfortunately, it always, instead of just picking up 911 and calling for officer to come out, which I was always very reluctant to do because I've heard the horror stories, I always tried to get an order of medical protection signed so that when the officers came out, they knew what they were dealing with. They knew usually it would be the same officers that were maybe better trained, and they didn't have to discharge a weapon or a taser or anything, because that's always a scary thought that you might kill your own son by calling. So I always tried to do the order of medical protection. Unfortunately, I think I waited a little too late this time. I really did.
I'll pass the witness, Your Honor.
Sanders, any additional questions for Ms. Key?
No other questions, Your Honor.
Is she free to go?
Yes, Your Honor, she is.
All right, Ms. Key, thank you. You're free to go. If you want to sit back, and if you want to stay for the remainder of the hearing, you may so. Anything further, Mr. Sanders?
No, Your Honor.
Argument, Mr. Sanders, go ahead.
Yes, Your Honor. I think it's pretty clear that Mr. Key was not indicted within 90 days of his incarceration, which began early December of 2019. He wasn't indicted actually until April, I believe April 24th of 2020. And I know he has been indicted now, but the law basically says that if the state's not ready within that 90-day period, then a defendant's entitled to a PR bond or a bond reduction, basically to the point where they can make bond. I know we delayed things because of the issue with him going to Terrell State Hospital, which I believe was something that was necessary based on the evaluation that was done. But I also believe, Judge, at this point that's the same rule, 17.151 would still apply regarding being entitled to a PR bond. And Judge, and I know that there will be concerns. It's a serious offense that's alleged. So I know that there are concerns. I believe that his mom is taking what steps she could to try to make sure that if he's granted a PR bond, that he would then be able to have a place to stay and to make sure that he's getting the proper mental health medication. But also there is the more recent concern. I think this is noted in the competency report from Terrell when he was released, that there was a health medical issue concerning his heart that I do believe needs to be addressed. I know Josh has concerns about that, obviously. And so that's something that would, I believe, factor into the granting of a PR bond in this case. That's what we're asking for today.
Mr. Sanders, how long has Mr. Key been in jail?
It's been a year and 2 weeks. He was taken into custody. It would have been November of 2019, but I think they took him initially to Terrell State Hospital, and then he was brought to the Van Zandt County Jail beginning of December, I believe December 3rd of 2019.
All right, Mr. Cox, any argument?
Briefly, Judge, we just have concerns about Mr. Key and his medication and his mental health. Should he be released from confinement? But we're going to defer to the judgment of the court on this issue, the issue of bond.
And Mr. Sanders, under Article 17-151, I believe Section 1 says that a defendant who is detained in jail pending trial of an accusation must be released on personal bond or by reducing the amount of bail required if the state's not ready within that 90 days. During that 90 days, Mr. Key was confined or detained in a mental health authority. Is that correct?
Well, even if you begin December 3rd when he was brought here to the Van Zandt County Jail, the 90 days would have been up, I believe, March 3rd. And I believe that was even before the motion for a mental health examination was filed, or was right around that time anyway.
I didn't hear any evidence regarding Mr. Key's ability to make bail.
Well, Judge, I believe that's when I asked his mom about what money or what funds he would have access to. He has some money in an account from the disability, but he has no way of accessing it whenever he is still incarcerated, and she can't access it from what her testimony was.
There's no way to get a power of attorney signed to access about $10,000.
That was my understanding. And I guess that's something possible that she could look into doing. But I know that hasn't been done anyway.
But you do agree with me, the testimony is there's about $10,000 sitting in his account.
Right, there should be, if it's been about a year, $800 a month, right, that would be probably around $10,000. And there might have been more, but prior to that as well, I'm not sure.
And do you have any argument as to what bail bond companies accept these days as market rates?
Yeah, no, normally it's 10%, sometimes less. So I know that, if we go with the $10,000 figure, then if the bond was reduced to $100,000, then that would be an amount that he would be able to make, assuming that there is $10,000 that they'd be able to access.
All right, then the court, based on the evidence and argument of counsel, will find that Mr. Key was not indicted within 90 days of being arrested. The court will find that Mr. Key does have access to funds for the posting of bail in this case. The court will reduce the bail of $200,000 to $75,000. Will also condition that posting of bail on the administration of a GPS tracking device on Mr. Key to assure his remaining in the jurisdiction of the court and that he will return to court when hearings are set. So the court will grant the motion, reduce bail to $75,000 and impose conditions. And Mr. Sanders, if you'll prepare an order to that effect, I don't know that if you've already provided one, the court will.
Yeah, it should have been filed with the motion. It may need to be modified a little bit and marking out the PR bond part. But.
I found it. I'll modify it. I'll get that signed today, Mr. Sanders.
Okay. All right. Thank you, Judge.
All right. Thank you, Mr. Sanders.
And Judge, I believe that when we had his arraignment a couple of weeks ago, I believe a pretrial was set for January the 7th. I don't know if we need to do another reset for that, or I think we already did the reset from arraignment, so I don't know if we need to do that today.
I don't show it set in January yet.
Okay.
Clerk's file says set for pretrial today, and then we set motion to reduce bail on the same day.
Okay.
So, do you have any contested pretrial motions?
We're sitting today for pretrial? I was thinking that.
That's just what they're.
No, because there aren't any pretrial issues, so that's fine.
Let me just look at our last appearance and announcement form on 12/3. No, you're right, Mr. Sanders. It says pretrial set on January 7th. So you're correct. I think it said arraignment that was marked out, then it said pretrial. So pretrial is set January 7th, so we don't need a new notice of appearance form.
Okay. All right.
All right. Thank you, Mr. Sanders.
Thank you, Judge.
Mr. King?
You could maybe.
All right. Yeah, well, I was going to call your case again. So, Mr. Curley, please. Hang on. Let me get us back on the record here. Back on the record. Really, go ahead, Mr. King.
Just we went back and looked at the prosecutor mentioned 42A.053.
limitations on assessing probation. They have nothing to do with the court being able to perform probation. Additionally, 42A053, there must be a adjudicated guilty act to apply. Also in section 10 said injury to a child with first degree felony or that's all it says. It says and victim was a child. I don't think he did this intentionally. I think he just did mistake. But it doesn't apply at all. And I just want to bring that to the court's attention. It deals with the limitations to set probation. It deals with only adjudications of guilt, and before injury to a child applies, it has to be a first degree felony and the child is a third degree felony. Just want to make sure. That's the mention. I'm sorry.
Sir. All right, the court, based on the evidence and the argument of counsel, at this time is going to deny the defendant's motion to reduce the term of community supervision. The court's going to find that based on the seriousness of the offense, the court has reviewed the stipulation of evidence from Mr. Curley's placement on community supervision. The court's going to find that due to the seriousness of the offense, discretion of the court, at this time the court does not feel it would be appropriate. The court is impressed with Mr. McCurley's progress. The court has not taken the evidence that's brought before the court lightly, and court would agree with Mr. Bingham that what we do want is Mr. McCurley's clients to be the example, to be the benchmark of what we expect. Just however, at this time, at 26 months into the 16-month term, the court does not feel it would be in the best interest of the community at this time.
May I ask one of the court?
Yes, sir.
This man believes that this probation officer, as well, she mentioned that they had taken the classes for chaperoning. Could the court allow, if the biological mother and father were present, Mr. McCurley's biological mother and father, that he could see his kids and supervise?
I think that we would need to make a motion to modify the community supervision conditions, give the state notice, and then bring that before the court. I mean, obviously the court would entertain that. I would definitely let you argue that motion and bring that notice. All right, so you understand the ruling of the court, Mr. Hurley? Okay. All right, so until that motion's filed, then the court's going to deny your motion at this time. If that motion is filed, then we'll put you back on the court's docket.
Thank you, Judge.
Thank you, Mr. Bingham.
May I have an excuse?
Yes, sir.
Your Honor, may I have
You may. See, this is Miss. All right, and the request is to reset.
We're kind of, I got hired 2 weeks ago. I have not been able to get the stuff that I'm trying to get. Of course she is. I don't know what the court schedule looks like.
We're maxed out. I could do the early.
I think
Contested days. That's all it is. Do it contested.
we could put it on a contested day, and if we need to go forward that day, I would rather put it as status and not set it as contested in case I run into a snag. But whatever the court wants to do.
If we're not going to do contested, then we can set February 9th.
Let's set it February 9th, and if I were able to, let's set it for February 9th, Your Honor.
And Miss Lambert's not going to have any objection because she's aware that she's not having a hearing today.
Yes, sir. And I told her that the court has some very strong concerns about COVID and limiting numbers. We're pretty regimented on that. So,
all right, court in CR 19-200 State versus Kelly, Longoria Lambert will set Miss Lambert's hearing on February 9th at 1:30 if she's in custody, 9 a.m. if she's in jail. Mr. Ashburn, are you ready?
Yes, Judge.
Who are you ready on?
Judge, let's make a request to get my clients who are needing resets. So I think that would be most expeditious. So Mary Rumbo.
Ms. Rumbo, CR 22-7, if you'll come to the middle podium here. And CR 22-7-1, we're set for pretrial today. Are there any contested pretrial motions?
We don't have any contested pretrial motions. I'm gonna make my oral request and I'll follow it up with a written motion for leave to file any additionals if we hit a tripwire. But I've conferred with Tyler Woodbook. This is his case, been assigned to him recently. I've made what the defense would like is a plea recommendation. He's considering it and reviewing the file, and we just asked for a short reset. We think we're going to come to a resolution with this very quickly, Judge.
All right, court will set this for docket call on February 9th at 9 a.m. Mr. Ashmore, while you're filling that out, Ms. Rumbo, I show that you're delinquent on your pretrial release conditions. You haven't paid your attorney fees, you're behind on your supervision fees. So after today, I need you to report your probation and you need to get with them to make payments. Otherwise, the court may conduct a hearing on whether you should be in jail waiting for trial or you should be on bail waiting for trial. You've been ordered to do those things. Okay?
Yes.
Yeah, don't tell me anything. I want you to report to them and take that issue up with them. Yes, you can come on back and have a seat over here and Ms. Burns will be with you when she's ready. No, ma'am, that's the one spot over there. You get there, I'll start questioning you about stuff. Right there. All right, who are you ready on now, Mr.
Ms. Musgrove, Your Honor.
Ms. Musgrove, if you'll make your way to the center podium, please. This is CR 2221, State versus Brianna Musgrove. Set for docket call today?
We are set for docket call. We have an offer of a possible offer of safe P, 5 deferred court cost fines. Again, this is Mr. Woodwick's case. We've conferred on the phone. I'm going to make an oral motion. I'll follow it up with a written motion for leave to file additional pretrials. I don't foresee the need for that. I think we are going to come to a plea offer, and I'd request for a short reset for a docket call so we can have a chance to further resolve this.
I show that Ms. Musgrove did not report in November as ordered, and she's delinquent in financial obligations.
That's correct, Your Honor. She was given this form this morning, and we had a conversation about the conditions of her pretrial release. That's part of the deal for getting a court-appointed attorney. She had a misunderstanding about that before. She has started a new job, and which is a blessing here in the ongoing pandemic. She's working as a property manager, and she's going to get all that squared away. She didn't quite understand all those before, but I've admonished her about that, and she's going to be compliant going forward.
Tell you what, if she passes her drug test today, then I'll do what you want to do. If she doesn't pass the drug test, then she may do what I want her to do, which would be go to jail. Okay?
Understood.
So just go ahead and have a seat over here. We're going to administer QA, and then I'll call you back up. Who's next, Mr. Ashmore? Ms. Munoz. This is F1915 and CR 2183.
Yes, Judge. This is a food stamp abuse, and there's an injury to a child allegation. She's got an ongoing CPS case. My understanding is that CPS case is going well. I've been told that she's got some clean UAs. I want a chance to provide those to the state of Texas so we can figure out what we're going to do about our resolution. And then there's likely, we anticipate a plea, but part of that's going to have to resolve both the financial restitution for the food stamp issue as well as that
Do you have
to a child.
Do you have any contested pretrial motions?
Don't. And again, don't anticipate any. I make that oral motion for leave. If I see one, I hit a tripwire.
All right, court will set Ms. Munoz for a docket call on February 9th. And on that day, the court would expect to hear whether or not this case will be resolved by plea agreement or request for a trial.
Hey, Ms. Munoz.
Once she receives her yellow copy, she's free to go. You ready on next, Mr. Esther?
Nichols.
Mr. Nichols, David Jordan Nichols, 2019-374. Set for hearing on motion to adjudicate or motion to revoke. Go ahead.
May I approach?
You may. Yeah, please.
Well, it's plea true to the revocation, and we have an agreement with the state of Texas on the weekends. 6 days, Van Zandt County Detention Facility, and there's an agreement to do those on the.
Judge, I'll need you to sign here.
My apologies, Judge.
Is this a case we have moved up to my court, or is this a county court law case?
Judge, I believe it's been transferred based on Judge Winter's recusal.
Okay, thank you. I saw his name on here. I wanted to make sure. And Mr. Ashmore, I'll need to get this. I need all that filled out with name, cause number.
I'm sorry. That's on my.
All right, Mr. Nichols, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, Mr. Nichols, you are David Jordan Nichols, is that correct?
Yes, sir.
Mr. Nichols, you appeared before the court on July 24th of 2019, and that was in the county court at law here in Van Zandt County. The court heard the evidence concerning your charge of theft of property 100 to 750, found that there was enough evidence to convict you of that offense. The court assessed your punishment, found you guilty, assessed your punishment at 180 days confinement in the county jail, and assessed a $500 fine. The court then suspended that sentence, placed you on community supervision for a period of 1 year. It's during that period that the state filed this motion to revoke the community supervision. And Mr. Nichols, have you had an opportunity to review that motion with your attorney, Mr. Casey Ashmore?
Yes, sir.
Mr. Ashmore, does your client waive the reading of the state's motion to revoke?
He does waive it.
And does he intend to plead true to all counts?
He does.
All right, Mr. Nichols, as to counts 1, 2, 3, 4, 5, 6, 7, how do you plead to those counts? Are those counts true or not true?
True.
And Mr. Nichols, are you pleading true to those counts because those counts are true and for no other reason?
Yes, sir.
No one's threatened you, forced you, or pressured you to plead true to any of those counts. Is that right?
They're not.
And the plea agreement in this case is, upon your plea of true, the state's recommending that your community supervision be revoked, that your punishment be assessed at 6 days confinement in the county jail, that you be ordered to pay the balance of your financial obligations, and the court, or the state's recommending to the court, that your sentence be served on January 8th and January 22nd, respectively, with weekend commitments. Is that your understanding, Mr. Nichols?
Yes, sir. That's right.
And that's what you're asking the court to approve?
Yes, sir.
And Mr. Nichols, you understand that if you do not show up on those dates, that you could be charged with an offense of escape?
Yes, sir. I do.
All right, the court based, let's see, Mr. Ashmore, is there any objection to the state's Exhibit A, the defendant's waiver of rights and plea of true?
None, Your Honor. We reviewed those documents.
Do I have, let's see if I have those documents. Do you have those documents?
Yes.
Okay.
I had to fill
That's the one.
That's the one that I needed signatures on. Sorry, Judge. It's okay.
All right, court admits defendant's waiver of rights and plea of true as state's Exhibit A. Court takes judicial notice of Mr. Nichols' judicial confession. Is there anything further from the state?
No, Your Honor, we rest and close.
From the defense?
No, Your Honor. Thank you.
All right, Mr. Nichols, based upon your plea of true and the evidence before the court will find that you have violated the terms and conditions of your community supervision. The court will follow the plea agreement in this case. The court hereby revokes your community supervision, assesses your punishment at 6 days confinement in the Van Zandt County Jail. Court orders you to pay the balance of your financial obligations. Court orders you to serve your jail on Friday, January 8th, 2021. To be admitted by 8 p.m. and to be released the following Sunday, January 10th, 2021, by 6 p.m. Court will also order you to serve the remainder on Friday, January 22nd, 2021 at 8 p.m., being released on Sunday, January 24th, 2021 by 6 p.m. Mr. Nichols, when you leave today, you need to make sure that you have a copy of your judgment. You need to make sure that you have a copy of your special order of commitment. And when you report to the jail, you need to have both of those documents with you, along with a photograph ID so the court can verify that you are who you say you are. If you show up without those things, the jail's not going to let you in. And if they don't let you in, they're also going to report that you did not serve your confinement. And that may result in new charges being filed for your arrest. You understand that?
Yes, sir.
So your judgment and the order of commitment to jail and a photograph ID. All right, Mr. Nichols, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step forward here with the bailiff to be fingerprinted. And then after that, just have a seat over here, Mr. Nichols. Mr. Nichols.
He's got one question.
Oh, no, hang on.
Yeah, I'm sorry.
Mr. Nichols, hello.
Yes, sir.
Trying to tell you something very important.
Yes, sir.
After you're fingerprinted, you speak with Mr. Ashmore, have a seat over here, and then Ms. Burns will be with you and get you that paperwork you need so you can finish your sentence, okay?
Okay.
Go ahead, Mr. Ashmore.
Do you think it's going to get that judgment the judge was telling you about? I'm sorry about that.
That's all right.
Forgive me.
All right, who are you ready on next, Mr. Ashmore?
Ms. McKnight?
Ms. McKnight, if you'll make your way to the center podium, please. This is cause number CR 2181, State versus Tatiana McKnight. We're set for docket call today.
We have a pretrial intervention contract. We have it's all signed off and sworn to, Judge.
Mr. Cox, will you sign this on behalf of the state?
Thank you.
Mr. Ashmore, I don't see where the attorney fees are addressed in the pretrial intervention contract. Is that part of the pretrial intervention program? It's for her to.
That one. That's my fault, Your Honor.
All right, so I'll recall her case in just a moment. I need you to speak with her about, because you're billing the county $750. And usually that's required to be
That's part of that
reimbursed.
agreement, and I should have caught that, Your Honor. I apologize.
So I'm gonna give these back to you. I want you to talk to her about that, and if she still wants to do that, then you'll let me know.
Okay.
But we'll need to have that put into the contract.
Very well, Your Honor. And then Mr. Ojeda is ready, Your Honor.
Mr. Ojeda? CR 18216.
Judge, this was a motion to early discharge probation, so Mr. Ojeda can go on courses, misdemeanor credit card abuse matter. And we're going to withdraw that motion today. We've conferred with probation. State's not opposed generally to the concept, but probation wants him to tune up a few things. So we're just going to ask the court to let him be excused, and we'll reset that in probably about 30 minutes.
Okay, Mr. Ojeda, court will reset your motion for discharge of probation on February 9th. What do we decide on Ms. McBride? Anything?
Ms. Abby's working on papers, Judge, and we'll be ready.
Okay. Bailiff in the jail court. Is Mr. Sanders ready, or do you need?
Yes, Your Honor, he's ready.
All right, Mr. Sanders, is this Mr. Lunsford?
Yes, Your Honor, it is.
Go ahead.
Judge, we're set today for a revocation or motion to adjudicate. Judge, I was just appointed last Thursday. I've been in touch a little bit with the state, but I was asking for some more time, partly because the main allegation in the motion to adjudicate is a new offense out of Henderson County, I believe. And so I was needing to get a copy of the discovery of this new case before making a decision about entering a plea of true or not.
Any objection from state?
No, Your Honor.
Thank you, Ms. Heisel. All right, Mr. Sanders, we'll reset Mr. Lunsford then. I believe have I previously set you today, Mr. Sanders? I think so.
Not, no.
Let's set this on February 9th. And if you reach an agreement with the state before then you'll let me know. We may be able to get you in sooner.
Okay, all right, that'd be good, thank you.
So February 9th. Anything further, Mr. Sanders?
Judge, I did have another question on Jeremy Ward. Do you want me to come back and get the amended conditions of probation and bring over here for him to sign?
Burns said that you would be a Christmas gift to her if you did that.
All right. Anything I can do to make her day.
All right. She does appreciate it.
In your honor,
Yes, ma'am.
I understand Ms. Twitty has already had a reset form signed. I believe that means that we're done with the jail docket. Is that correct?
Ms. Twitty, there was the state's motion was withdrawn and I believe dismissed. And I'm looking through here. I think Mr. Yates is not in jail. I believe you're correct. I don't believe anyone else is in jail.
Very good.
Thank you for being over there and helping.
Yes,
tell
sir.
Deputy Casper I appreciate his help as well.
I certainly will, Your Honor, and I'll be back shortly.
All right, thank you. All right, Mr. Ashmore, are you ready on anyone else?
Judge, I'm gonna,
What about Mr. Yates, Robert Yates?
he's in jail.
Oh, well, they just told me that,
He didn't make, I don't know if he made bail, but he was dirty last time, which is why he's in jail. And Ms. McKnight is going to ask the court for a reset the week of New Year's because she needs to come up with that 500, and it's going to be a struggle to do that today prior to Christmas.
just a second, she didn't have to pay it today.
Judge, it's our policy on PTIs, fee be paid up front.
Yeah, this is just attorney fees. This is not PTI fee, right?
Judge, this is.
Yeah, it's condition 5, and I didn't.
She hasn't paid her 500 PTI.
Yeah, the fee to the.
But you know what I'm talking about? It's not the PTI fee.
I do. So we have 2 issues. So if there's any room on that week.
Mr. Ashmore believes that Robert Yates may be in custody out there. It's not on my docket as in custody, but I don't know. Can you double check? And if he is. Robert Brandon Yates. All right, if you can grab it. All right, thanks. I'll get logged back in. I'll bring you back in. All right, thanks. All right, Ms. McKnight. CR 20181. All right, so you're asking for a reset to enter in a plea to the pre-trial conviction contract.
Yes, Judge.
We're going to set that on February 9th at 9 a.m. down to 3. I think we're down to Musgrove, Gates, and we're bringing Mr. Yates in.
Your Honor, Mr. Yates is on his way.
Thank you, bailiff. Appreciate that. Sorry, like I said, it's not on my docket, so I thought we had him covered.
We're making it work.
All right. Well, I'm going to mute you, and we're going to move on to a couple others real quick.
Yes, sir.
All right. I need an update on Miss Musgrove. How do we do on our UA?
Well, she had some.
All right, Miss Musgrove, make your way to the center podium. Mr. Ashmore, are you available on afternoon of February 5th? Yes. Say January 5th?
February 5th, Your Honor. January 5th.
You're sorry, be myself.
Yes, sir. I can make that work. We've got a veteran that I'm going to try to get into the Aller detention program, but I can get coverage for that. So I can make that work, Your Honor.
So what I'll do for you, Mr. Ashmore, I'm gonna set Miss Musgrove February 9th. And Miss Musgrove, the court's going to have your analysis sample that you provided sent off to the lab for confirmation. We're going to come back and we're going to discuss your case, and we're also going to discuss that UA status on 2/9.
Yes, sir.
And on 2/9, I'm going to expect if there's a resolution of the case, Mr. Ashmore, then the court won't be interested in the UA confirmation. If there's not a resolution, then we'll definitely talk about the UA. And I'll tell you, Miss Musgrove, based on your body language alone, when I said I was going to UA you, I knew you'd be positive. I knew
When
it.
she asked me, I told her, I took Adderall.
I understand.
I didn't.
Understand. But people with an explanation, a reasonable explanation, they don't have that body language because they have a reasonable explanation. So I'm just going to tell you what my, intuition on you was. When I said that, every time I order somebody to a UA, I look at what their facial expression does and what their body does. The time from you walk there to walking there, I knew you were positive. What I should do is just find you in violation of your conditions of pretrial release and put you in jail, let you sit there through Christmas and New Year, and see if you come out with a different attitude. That's what I should do. I'm not going to do that. I'm going to let you stay out. I'm going to let you work with Mr. Ashmore, and maybe you can resolve your case on February 9th.
Okay, yes, sir.
Understand?
Yes, sir.
So I would consider that a blessing, and I would get with Mr. Ashmore and figure out what your announcement to the court is going to be on February 9th.
Okay.
Mr. Ashmore, once she signs that, then she'll be free to go. And Miss Musgrove, you need to, if you haven't already, you need to talk with Miss Burns about your delinquencies and also. Deputy McLeish, is this Mr. Yates?
Yes, Your Honor, it is. Go and stand.
All right, this is cause number CR 20-97, State versus Robert Yates. Set for docket call today. Mr. Ashmore, go ahead.
Yes, Judge, we don't anticipate filing any pretrial motions. We just got a plea offer from the state. I need some time to talk about it with my client. The court may remember that he's in custody because he tested positive at our last setting in November. And I'm going to again ask the court for leave to file an additional pretrial motion if we hit a tripwire, and ask us for a short reset so we can get this case pled.
What's the, remind me again, maybe you said this and I just didn't hear you. What's the?
Oh, I'm sorry, I didn't say it. No, it's 10 years TDCJ is the current offer that Mr. Cox extended. And we have been conferring with our client, but it was about seeing about bail reductions, and we were conferring with the state about that in light of the holidays. And I am remiss for not getting that offer quicker, so I apologize. That's on me, Your Honor.
Any objection from state?
No, Your Honor.
All right, we're going to set Mr. Yates on February 9th for docket call. If you and the state reach an agreement before then, you'll let me know, and I may be able to get Mr. Yates before the court.
Absolutely, Your Honor.
All right, thank you, bailiff. I believe that does resolve the jail.
Thank you, Your Honor.
Did I get a phone number?
No, sir. Your attorney's going to come visit with you when it's.
Oh, okay. Thank you so much.
Mr. Yates, any questions?
I didn't know, I mean, honestly, I didn't know about the bond reduction or not, but I did want to say thank you. I was dirty whenever I was in your court before. You saved my life. Praise God, you did. You saved my life. I'm clean. You did. You saved my life.
Well,
I'll have to come back here.
You're very
Thank
welcome.
you so much.
Good luck to you, Mr. Yates. I'll see you shortly, Your Honor.
Not if I see you first. All right. Miss McBride. This is cause number CR 2135, State versus Tanya Lucretia McBride. What's the?
We have a plea agreement. It's a 10 deferred restitution. It's supported by state. We're going to stipulate to it approximately $115,000, $119,000, and we're waiting on paperwork.
The delay with the paperwork, Your Honor, if we didn't know how much McBride would agree to, also didn't know how much the court ordered and haven't even told me. McBride has paid the full $119,000 and notified Ms. Abney she's working with it. You're right.
And we want to do this today.
Yes, sir.
How long maybe? I believe that I could, if this is the only case left and we're not going to have a hearing, we could take this up at 1:30 before my technical hearing. Want to do that? Give Miss Abby time to get the paperwork produced.
Witness, nice.
I'm going to do that. I got to get my staff here a break because once you all leave, then we continue throughout the day with other hearings. So we'll make sure she gets a lunch break, time to rest. So, all right. So we will resume court on this case at 1:30. We'll take it up first. Thank you, Ms. Heisel.
Thank you, Judge. Merry Christmas.
Christmas. Yes, sir.
Is that a fidget spinner?